Did you know, according to the U.S. Bureau of Transportation Statistics, in 2012, over 642 million passengers boarded domestic commercial aircraft. They went through advanced imaging technology, also known as full-body scanners. A couple of weeks ago, I had the opportunity to go on a business trip to Washington, D.C. I went through full-body scanners. According to the Transportation Security Administration's website, there are 760 scanners in 170 airports in the United States. When you go through these full-body scanners, your Fourth Amendment rights are not being violated. One of the freedoms provided for us in the Constitution is the protection against unreasonable search and seizure. This is known as the Fourth Amendment. I'd like to take an opportunity to review that amendment with you. The Fourth Amendment, and I quote, reads, "The right of people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Now, the amendment has three very important parts. First of all, let's examine search. According to Jacqueline Connovitz in our constitutional law textbook, search, and I quote her, occurs when police intrude on a suspect's reasonable expectation of privacy. And I would like to continue to quote her about seizure. And this occurs, I quote, when they interfere with a suspect's possessive rights of property. Now, we also must examine reasonableness. According to Black's Law Dictionary, reasonableness, end quote, is a particularized and objective basis supported by specific and articulable facts for suspecting a person of criminal activity. The issue of reasonableness has triggered exceptions to the Fourth Amendment. First, we must have to think about how unreasonableness is determined. According to a 2001 U.S. Supreme Court case, known as U.S. v. Knights, unreasonableness of a search is determined by, and I quote the Supreme Court, assessing on one hand the degree to which it intrudes upon an individual's privacy, and on the other hand the degree to which it is needed for the promotion of legitimate government interest. There are two exceptions to the Fourth Amendment. One is called Terry v. Ohio. This is a Supreme Court ruling that states that law officers can perform limited search and seizures when they have reasonable suspicion that someone is involved in criminal activity. The second is the administrative exception. In 1973, the Ninth Circuit Court ruled on U.S. v. Davis. And they say the administrative exception applies to search under, quote, regulatory situation to further an urgent, quote, urgent interest. Airport searches to protect against terrorism and other threats meet this expectation and are excluded from the strict requirements of the Fourth Amendment. Now, there are some guidelines of airport security administrative searches, also from U.S. v. Davis, and I quote, An administrative search is allowed if no more intrusive than necessary in the light of current technology to detect weapons or explosives, confined in good faith to that purpose, and passengers may avoid that search by electing not to fly. In a 1986 case known as U.S. versus Paleto Requerez, the Ninth Circuit Court upheld U.S. versus Davis and stated, according to, and I quote, according to regulations, the searches must be carried out in a reasonable amount of time with minimum amount of intrusion. Now, according to the TSA, or Transportation Security Administration's website, in November 2001, Public Law 107-1 was signed by President George W. Bush. This law was titled the Aviation Transportation and Security Act, and it led to the formation of the Transportation Security Administration, also known as the TSA. It also led to the development of current security purposes. The law also gave the Department of Homeland Security and TSA legal freedom to conduct searches using current methods without fear of violating our Fourth Amendment rights. Let me read you the statute. Quote, anyone boarding a commercial airline flight must be screened by the Transportation Security Administration in order to ensure he is not carrying unlawfully dangerous weapons, explosives, or other destructive substances. Now, in late 2010, the Transportation Security Administration implemented new rules requiring passengers to submit to either advanced imaging technology or full body scans or enhanced pat-downs. Now, there were concerns, of course, about full body scans and privacy. The most recent case was decided on July 15, 2011 by the U.S. Court of Appeals. The Electronic Privacy Information Center and two individuals petitioned the U.S. Court of Appeals for a review of the Transportation Security Administration to determine if this type of imaging violates federal statutes and the Fourth Amendment of the Constitution because it is more invasive than necessary to detect weapons and explosives. The ruling from the Supreme Court, and I quote, in the view of the Supreme Court's repeated refusal to declare that only the least intrusive search practical can be reasonable underneath the Fourth Amendment, considering measures taken by the Transportation Security Administration to safeguard privacy, we hold advanced imaging technology does not violate individuals' Fourth Amendment rights. So with this recent ruling, we as individuals and citizens of the United States, and those who are not citizens of the United States who are flying on our domestic carriers, know that as passengers on these commercial aircraft, we will continue to be searched by advanced imaging technology, also commonly known as full body scans, or by an enhanced pat-down, without violation to our Fourth Amendment rights. So we are not being violated when we go through these full body scans.